In each of these matters, Mr. Lane is here today after failing to appear before referee Coleman on November 17th, 2023. In the first case, bond is currently set at $2,020. This is the fourth bench warrant. In the second case, bond is currently $6,919. This is the second bench warrant. And in the third case, bond is currently $1,976, and this is the first bench warrant. He reports no employment. Last payment made on these accounts was on December 1st of 2023. That was through income withholding through DFAS. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on December 20th, 2023 at 8:45 a.m. before this court.
Okay, thank you. Mr. Lane, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on December 20, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Well, if I could be like straight up front, because this is the first time I'm receiving anything. I've been on house arrest, tethered to my sister's house, fighting another case. I just got out of Nuevo County Jail, and since I've been in Nuevo County Jail, all these amounts have been accumulating. I was thinking, it's laws against this type of stuff. When somebody's locked up, especially under federal holding, amounts should be exempt from the person paying. And also I'm on supplemental income. You know what I'm saying? I only get the amount I'm getting. And I'm seeing, like, when I last seen, it was a while ago, like right before I got locked up, I was paying $965 or some amount for two kids, and I'm getting $991 for Social Security disability. I'm like, I can't afford none of this. Like, I'm not rich at all. I don't got no money like that. Like, this ain't doing nothing but just killing me. Like, might as well just take my life, because I ain't got no money like that. I'm trying. I can pay bare minimum.
Sir, you can always file a petition to modify support.
I can't. I'm on house arrest. Like, everything is against me right now. I ain't got no means to do anything. Everything I gotta do, I gotta report to a judge and report to my PO.
Are you gonna keep talking, or are you gonna listen?
Okay, go ahead.
I said you can file a petition with the court to have a modification of your child support. You can get the petitions at the clerk's office. If you're under house arrest, you'll have someone else pick those up for you. You can fill those out, send them in, or have somebody drop them off. But it sounds like, on what you're saying, that you should have the matter reviewed, but the court doesn't do that on its own initiative. You have to take the initiative to do that. And if you don't, then you suffer the consequences of that. Getting back to my original question, are you able to post a bond in these cases?
Not until like the 22nd or 23rd of this month. That's when I get my next payment, and it's only $991. I could try some bare minimum today. Like, if there's anything you can accept. Okay.
Well, what I'm going to do is, you do have the fourth bench warrant one. You have sizable arrearage. What I'm going to do is I'm going to set your bond in each case in the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
Okay, so each case the amount of 100. So how many cases?
You have 3 cases, so it'd be $300.
$300.
Yep.
Okay.
Thank you, sir. You're free to go.
DS.
You can leave, sir.
Ms. Worsup is here today after failing to appear before this court on June 16th, 2021. Bond is currently set at $1,430. This is the second bench warrant. She reports that she is employed at Howard's Motel. Last payment made on this account was in February of 2018. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 20th, 2023 at 8:45 a.m. before this court.
Ms. Worsup, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on December 20, 2023 at 8:45 a.m. Are you able to post a bond, ma'am?
Yes.
Okay, how much would you be able to post?
Wait a minute, wait, we're posted bond, like what? I'm stuck in here till the 20th.
You're gonna have to speak up.
I'm stuck in here till the 20th on another charge, so I will be going nowhere.
Okay, I'm asking if you're able to post a bond.
I don't know.
Okay,
I can't answer that, I don't know.
well, it's the, you only have, two prior, bench warrants in this matter, the court's taking that into consideration, but you do have a significant, support arrearage. What I'm gonna do is I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you. You're free to
Mr.
go.
Laronis
Have
is
a
here
good day.
today after failing to appear before this court on September 20th, 2023. Bond is currently set at $652. This is the fifth bench warrant. He reports that he is employed at Laronis Instruments. Last payment made on this account was in September of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 20th, 2023 at 8:45 a.m. before this court.
Mr. Laronis, you're before the court charged with civil contempt of court for your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 20, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I don't, I hope I am.
Okay.
I wasn't, I know that when I was down here last time, I think I paid like $600 or what, and I thought that was supposed to go towards that, some of the arrears or whatever on the child support.
Well, it would have.
Yeah, that's what my understanding was of it. And I thought I was all set. I didn't realize that I had a hearing or anything. Maybe I'm sure it's my fault.
Okay. Well, what I'm gonna do, I'm gonna reduce your bond in hopes that you could be released. I'm gonna set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't, but I really appreciate that.
Okay, thank you, sir. You're free to go. Have a good day.
In each of these
Thank you.
matters, Mr. Wines is here today after failing to appear before this court on November 9th, 2022. Bond in the first case is currently set at $2,231. This is the seventh bench warrant. In the second case, bond is currently $1,729, and this is the eighth bench warrant. He reports that he is self-employed. Last payment made on these accounts was in March of 2023. Front of the court recommends that reasonable bonds be set in each of these matters and they be scheduled for hearing on December 20th, 2023 at 8:45 a.m. before this court.
Mr. Wines, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 20, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post bond at this point, sir?
I mean, it just depends on what it is. I don't have a whole lot of money, but I got a little bit of money.
Okay. Well, what I'm going to do is I do note you have, the one case you have 8 bench warrants, the other 7, so you have a substantial amount of bench warrants. In this case, you do also have a substantial amount of arrearage in both of these matters. What the court is going to do is I'm going to set your bond in
Sure.
each case in the amount of $300. So if you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day. Ms. Morris, I'll start with you because you're the plaintiff, and in this particular matter, it's before the court for a status conference just to check on the case and where we're at. I do note that the front of the court had filed an objection. Have you addressed that objection with the with the front of the court?
I tried to call their office.
I said Miss Morris, sir.
Okay.
Good morning. I
morning.
do have the paperwork. I was gonna send it out today to complete the rest of the stuff that I wasn't able to check.
Okay. So do you have that ready to go at this point, or you're just in the process of preparing that, or where are you at?
I have fixed a couple of things that needed to be fixed. I'm gonna overview it and send it out today if that's okay.
Okay. Well, what's going to happen is obviously it's not unusual to get those objections when, people are preparing them in, basically pro per. What I'll do is we'll reset this for about 30 days and review it at that time. So make sure you do get it out, because especially during the holidays, the court's going to be closed for a few of those days. So it'll take longer than it would normally take to get a response from the front of the court. So
Absolutely.
anything that you have, sir?
Nope.
Okay. Thank you. We'll see you back in about 30 days and be able, hopefully, if we get matters resolved, we might be able to take some proofs at that time and get the matter closer to at least completion. Okay.
Thank you.
Okay. Thank you both, and have a wonderful
At
holiday.
8:52
Thanks, you too.
a.m. Okay, very good.
Good morning to both of you in this matter. This is a scheduling conference whereby the court sets in place various times, deadlines, and procedures so that the case would proceed in an orderly fashion. I will go to the plaintiff first in this matter to determine what issues are in dispute. Mr. Hanker, what issues do you believe to be in dispute in this case?
Mostly right now is most everything with my doctor's meetings and everything right now, and that's just about it right now.
Okay, well, I need to know the issues in dispute. Are we fighting custody? Are we fighting parenting time, child support? What are the issues in your case?
Mostly just want some custody, and that's it.
Okay, so Ms. Gilman, is that your understanding of what's in dispute?
Yes.
Okay. Well, I'll put custody, support, and parenting time because they are all kind of dependent upon each other. So I will do that. Mr. Hanker, are you in need of discovery? Discovery is the process whereby you acquire information from the other side, and if there's anything that you need.
At the moment, not really. Just trying to get everything else I have to do.
Okay. Ms. Gilman, are you in need of discovery?
No.
Okay. The court will set February as the date, as the month for mediation. Mediation is whereby you'd meet with an attorney mediator and try to come to resolution of the various issues. Mr. Hanker, is there any mediator, it'd be an attorney mediator that you're acquainted with that you would recommend in this matter?
At this matter, no.
Okay.
I don't have.
Ms. Gilman, do you have anyone?
No.
Okay. Then the court will leave it up blank, and what happens, the mediation clerk will assign a mediator, and you'll get notice of that in probably about a week as to who that individual is. Mr. Hanker, because you're the plaintiff, you're going to need to contact that individual and set up a mediation date, and then make sure that with Ms. Gilman that she's available at that time, so that you can get the matter heard. And because the mediator with the holidays and that would probably be booked up in January, so that's why I'm giving you that extra month. Anything else, Mr. Hanker, that you have? Any questions, anything of that nature?
I don't have any right now, no.
Okay. Ms. Gilman, do you have any?
No.
Okay, thank you. What we'll do is I'll send out this case scheduling order. I would say make sure you pay attention to the dates in that order, because if you miss dates, it could have consequences to your case. So make sure you read it all through, recognize what the dates are for not just disclosure of information, but exhibits and witnesses and things of that nature. I will tell you that there is, with the mediators, there is a cost associated with that. And when the mediator is assigned and you contact that person, they will lay out that cost. You'll each have to pay 1/2 the cost of the mediation. Anything else, Mr. Hanker?
No.
Ms. Gilman? Okay.
I don't think the settlement conference date.
I've got it in. Oh, I've set up your settlement conference date for March 11, 2024 at 1:30 p.m. It's in the case scheduling order, so you'll just have to appear back on Zoom like you're doing now. Okay?
Okay.
Okay. Thank you. You have a good day and have a good holiday.
Austin
You as well.
Baldwin versus James Howard. Attorney Elizabeth Sachs for plaintiff and defendant is not here.
Court will note the appearance of Ms. Sachs on behalf of the plaintiff. This matter is before the court for evidentiary hearing on the complaint by the alleged father to determine child born out of wedlock, specifically age 10, well, probably maybe 11 months by now. Court will note that the mother, Nicole Bailey, passed away on September 29, 2023 in this particular matter. And Ms. Sachs, are you ready to proceed?
I am, Your Honor.
Okay. Do you wish to make an opening statement or simply proceed to proofs?
I'm happy to proceed to proofs, Your Honor.
Okay. And do you wish to have testimony?
I do. I'd like to call Austin Baldwin. Are you the plaintiff in this action?
No.
Plaintiff?
Yes.
At the time that you signed the complaint, were all of the allegations true?
Yes.
And do they remain true today?
Yes.
What is the child's full and complete name? Is he
Bentley
less than
Mike.
3 years old?
Yes.
Did you, the defendant, and Nicole openly and mutually acknowledge the biological relationship between you and the child?
Yes.
Did you know or have reason to know that Nicole was married when the child was conceived?
No.
Did you submit to genetic testing in this case?
Yes.
What company did you use to perform the testing?
DDC.
Did you, to the best of your knowledge, go to a licensed facility to collect your genetic sample?
Yes.
Do you have any reason to believe that the results of the test are inaccurate or altered in any way?
No.
Do you think that it is in the best interests of the child to revoke defendant's paternity?
Yes.
Do you think that it is in the best interests of the child for this court to enter an order of filiation that establishes you as the father?
Yes.
And that's all from this witness, Your Honor.
Okay.
At this point, I would move to admit the genetic testing, which has been prior provided to the court.
Court will, being obviously no objection, the court will admit as plaintiff's exhibit 1, the genetic test results dated December 5, 2023. Those were done by well, they were done in this matter. The court will note that they demonstrated a probability of paternity of the plaintiff of 99.998%. The genetic test results were signed in this matter by, Deputy L. Kumar, PhD. She's the lab director. And as a result, the court will enter that exhibit at this particular point. Were you going to have any more testimony, Ms. Sachs?
No, Your Honor. I would just note for the court as well that Mr. Howard has been found in default as of this past Friday.
Okay, that's fine. Being that you weren't, I didn't know if you had other testimony. I'm going to ask your client some questions that I have.
Sure.
Mr. Baldwin, in this matter, you had stated in your complaint that you and the decedent had resided together since what date?
I can't remember exactly what date. I know that, oh, actually, we got our home in October of 2022, which was October 15th.
Okay. Had you resided together prior to that time?
No, just seeing each other on and off.
Okay, had you, let me ask this, the important questions. Had you engaged in sexual relations with the decedent prior to that time?
Yes,
Did you engage in sexual relations with the, with Miss Bailey at or about the time of conception? Sir?
can you repeat that, please?
Did you engage in sexual relations with Miss Bailey at the time of conception?
Yes,
And do you know she had separated from Mr. Howard based upon the pleadings on or about sometime early 2020? Is that accurate as best that you're aware of?
best of my knowledge, yes.
And you resided with Miss Bailey and with Bentley from Bentley's date of birth, is that correct?
Yes,
And did you, in fact, carry on a parent-child relationship with Bentley?
yes,
Any doubt in your mind that Bentley is your child?
he is my child, yes.
Okay, anything else, Ms. Sachs?
Not at this time, Your Honor. We've already submitted a proposed order for this court to sign.
Okay. Well, what the court will do, the court will, based upon the testimony, as well as the genetic test results, in this case, the court will determine that, in fact, the child, Bentley, in this matter, is in fact a child born out of wedlock, that she is not issue of the marriage between Miss Baldwin and Mr. Howard, the defendant. The court will note that the default in this matter was entered on December 8, 2023, that Mr. Howard has not taken action in this matter by filing any pleadings. Likewise, the court will know it's now 1:41 p.m. He's not appeared on Zoom. I'll say that the courtroom is open today. He's not appeared in court as well to, again, contest this particular complaint. And as a result, the court will find that Bentley, the child born out of wedlock, not issue, as I stated, and that, in fact, the plaintiff, Austin Baldwin, is the biological father of Bentley in this particular matter.
Judge, the defendant did appear a moment ago. Does it matter? Should I bring him in?
Yes, yes.
Okay.
Mr. Howard has appeared, so contrary to what I stated, we found out that he did appear. Okay, Mr. Howard, in this matter, the matter was set for 1:30 p.m. We commenced just after that. I've taken the testimony of the plaintiff in this particular matter, as well as heard the argument by Ms. Sachs, the attorney. Is there any, did you wish to render testimony or present any proofs in this matter?
Correct, Your Honor. I've been raising the baby for 4 months now. CPS brought him to me. I've got attached to the baby. And then I have his biological brothers. I am biological father of them.
Okay, well, what I'll do, sir, is I'm gonna have you sworn in. We'll take some testimony because what you're saying to me at this point is not testimony, okay? What testimony, you can reiterate that if you wish, so we would have that as evidence, sir.
I've had the baby. The baby was brought to me the end of September. We're talking about Bentley. I've had him since then, raised him. And I've got attached to him. I bought everything he needs. And I have his biological brothers that they just lost their mother as well as the baby. They don't need to lose him.
Okay. Anything else, sir?
That's pretty much the basics of it, Your Honor. I fell in love with the baby.
Okay.
And the brothers daily play with him. I got video, I got pictures I can show you.
You acknowledge, do you not, that, again, you and the decedent, Miss Bailey, had separated sometime in early 2020, correct?
We had a marital incident, and that's where Bentley was brought into the world.
Okay. Well, you know that the court had admitted the DNA test results in this matter, and the DNA test results demonstrate that the plaintiff is the biological father.
Your Honor.
Are you aware of that?
I am now.
Okay. So for purposes of that, you are not the biological father in this particular matter. Ms. Sachs, did you have any questions for Mr. Howard?
I do not, Your Honor.
Okay. Anything else, Ms. Sachs, now that Mr. Howard is present?
Your Honor, I would just reiterate that pursuant to the Paternity Act and Revocation of Paternity Act, Mr. Baldwin has met his burden to prove that he is in fact the biological father, that it is in the best interest of this child to have the revocation of paternity be entered, and that an order of filiation be established for plaintiff to be the legal father of this child. And we ask that you sign as already filed by plaintiff in this matter.
Okay, thank you. Mr. Howard, do you wish to make any closing argument?
I wish that you guys would look into Austin's welfare of the child for the housing. If you see fit, he goes with him. I would like to keep the child with the boys as much as possible.
Okay. Anything else, sir?
That's it, Your Honor.
Okay. Well, based upon, I'll tell you, there's a lot of things that occur in these cases. And as I've stated to you, based upon the testimony in this matter, that it does appear that the plaintiff is the biological father of Bentley. And in fact, as I've stated previously, he had a relationship. He had resided with the child from the child's date of birth until the death of the mother back in late September 2023. And the court had made a determination that the child was a child born out of wedlock. It is not issue of your marriage to the decedent in this matter, and that the plaintiff is in fact the biological father. The court is going to so order. Sir, what's going to happen in this matter, you're going to have to turn the child over to the plaintiff in this particular case, Mr. Baldwin, as he is determined at this point to be the father of the child. So I assume that Mr. Baldwin will be coming to your home or making arrangements to pick up the child at this particular point. Is that correct, Ms. Sachs?
That's correct, Your Honor. We would also ask that if Mr. Howard has any documents of the child's, including a social security card, that those be turned over as well.
Okay. Well, hopefully he'll cooperate and do that. And Mr. Howard, if you wish to have some communication with Mr. Baldwin, you can do that through his attorney, Ms. Sachs. She did state some issues concerning wanting to have some contact between the child and the child's siblings. So you'll have to arrange that through Ms. Sachs, okay?
Okay.
Thank you. It's now
Thank you, Your
1:50
Honor.
p.m. The court will conclude this matter. You're free to go. Have a good day.
Thank you, Your Honor.
The court will note the appearance of Ms. Sharp on behalf of the plaintiff. The defendant is appearing in pro per. This is the time and place set for the evidentiary hearing on two matters: the plaintiff's motion for denial of parenting time for makeup parenting time, as well as plaintiff's motion for return of child and to enforce the orders. The court would note that the court had entered an ex parte order to enforce judgment of custody and to show cause for failure to comply back on July 25, 2023, which stated in the order in paragraph 1 that the defendant shall immediately return the minor child, Bella Joe, back, date of birth, to plaintiff for his parenting time. The plaintiff has subsequently filed an additional motion in this particular matter that was filed on November 27, 2023, stating that there has been an additional denial and that the child has not been turned over to him. Ms. Martinez, have you in fact complied with the turnover order in this matter? And I say that only because the most recent motion, the plaintiff had contained in paragraph 17 of the motion various texts from you, in fact, demonstrate or showing that you do not have the intent to comply with the court orders in this matter.
I did return Bella for visitations with her father until she was abused by her father physically. She came home with cuts to her mouth that were confirmed by her pediatrician, and then that is when I stopped.
Okay. It's my understanding from reading the motion that that CPS was involved and they did not substantiate. Is that correct?
They were at the doctor's office when the doctor showed them and confirmed to them the cuts on our daughter's lips. However, whether they followed their protocol for child abuse or not I'm not exactly sure.
Okay, well, I can only assume, I don't know, but I assume that they followed their protocol as they're required to do. Well, I guess the main point is, are you in fact refusing to turn the child over to the plaintiff?
Well, as of right now, yes. The plaintiff, Mr. Back, has pled guilty to domestic violence, which occurred July 1st.
That's the only point I want to make today, Ms. Martinez. As a result of your failing to turn over, as this court has ordered, the court is going to remand you to the Calhoun County Sheriff, where you will remain incarcerated until such time as the child is turned over to the plaintiff.
Okay.
So you can go with the deputy.
As I'm in court, how am I to allow the plaintiff to know where our minor child is?
You're going to have to make your phone call and make sure that whoever, where the child is, that the child is turned over. But at this point, you will remain incarcerated until such time as the child is.
But if I'm in jail, how am I supposed to get my child and give her to the plaintiff? I'm just trying to make sure that I know what to do from. You'll have to call somebody or let the plaintiff know where the child is so he can pick up the child. May I ask one more question? Yes. So we are going to follow the current parenting time order, which is from the plaintiff gets our child from 8 p.m. to 8 a.m. So the current orders have not been changed. They will remain in effect until such time as we have another. So I am to turn our child over to the plaintiff at 8 p.m. tonight? Is that, if that's the time of the turnover? Well, yeah, that is the time of the turnover. Yep. Well, in this particular matter, I do note that the court has previously, and there are makeup parenting times that are required. Ms. Sharp, what are the makeup parenting times that you've requested?
Bring them up, Your Honor. My client initially went without the child starting July 5th. And I believe she started to comply back with the order, was it in August?
I don't remember, she just placed me. I don't-
Okay, let me just look at my work. Quick. And then she stopped complying November 3rd and my client has not had the child since.
Okay, so in total, how many days is that?
35. That's not.
May I, Your Honor?
Just a minute, let's figure this out first.
Okay, yeah, I understand. Okay, so the first time was 29 and now my client's stating it's 34 overnights.
34 total or 34 this time?
Additional.
Okay. So we have a total of 63, it looks like.
Correct.
Is the total. Ms. Martinez, is that square with your understanding?
Yes, yes, it is. I was just wondering if the court was going to go by its recommendations that anybody that had pled guilty to domestic violence should not have 50-50 custody of the minor child because.
We are enforcing the orders that are in existence at this time.
Is the court going to investigate because of the domestic
Court does not
violence? of the plaintiff?
investigate.
Oh,
Other
the
agencies.
FOC handbook said it.
Other agencies investigate, CPS investigates, the police investigate, the court does not investigate.
And I was just wondering, because the FOC handbook says that the court would investigate.
Court will order that the child be turned over to him immediately, forthwith, and that he will have the child for the 63 days that he has been denied as make-up parenting time. Yes.
I can have my ride here. Cindy, go get the minor child and bring her here within a half hour. She is only about 5 minutes from here. If the court can wait a half hour, I can have her here in a half hour.
Well, okay, I'll have the deputy take you. He can take
Can you
you
go,
into the
Bella?
holding tank and then we'll see that the child.
I'm sorry, should she bring Bella here to this
You
courtroom?
do that when you go to jail, figure it out.
I can. There's a personal protection order against him and he continues to address me. When my friend Cindy goes to get Bella, should she bring her here to this
She can
court?
bring her back to the court. In fact, what we'll do is we'll have Ms. Sharp and her client, they can be out in a conference room and the child can be turned over to them. And at that time, once Ms. Sharp is confirms that he has the child, then we will allow your release.
Sure.
Okay.
Can you do that for me, please? Thank you.
Child has been turned over to your client, is that correct?
Yes, Your Honor, she's in the
Okay.
hallway.
Court will again reiterate that the child will remain with the plaintiff in this matter for the next 63 days for the makeup parenting time. And thereafter, the parties will then comply with the current order that's in place. Anything else, Ms. Sharp?
The only issue would be, Your Honor, is that the child goes to school and the school has given my client a hard time before because it didn't say that it was his parenting time at that time. It's gonna be probably the next 7 days since I had to do a 7-day order for it to go into place. So there is concern that the child won't be able to go to school because he can't drop off and pick up based off of what they believe is the current order, not. So but we just want to make sure she still can go to school somehow.
Oh,
Yeah.
Yeah, and if you want to add that in the order in case, it's necessary, because you're gonna have the child for 63 days, so you'll need it. So but the fact is that he does have opportunity or does have the right to take the child, pick up the child and be involved in the schooling. He would have that right anyway pursuant to MCL 722.30.
Yes.
Ma'am, don't shake your head unless you know the law.
I'm sorry, but the only reason why it's like that is because those are my parenting time hours. Mr. Beck doesn't have Bella during school hours. So that's why the school has that in place to follow the order to a T.
The law states that the non-custodial or the other parent, even if they're not a non-custodial, the other parent has the right to all information concerning schooling, doctor, etc.
Yes, they inform him about anything that goes on in the school, but just to follow the order to a T, he was not allowed to drop her off at school at noon or pick her up at 3:30 because those were not his parenting time hours.
We'll put that in the order, make sure that that's taken care of so that he is allowed to drop off, pick up and do whatever's necessary for the schooling purposes.
Thank you.
Anything else, Ms. Sharp?
Just that probably in the next 7 days, because it will be a 7-day order, he probably won't have the ability to take her to school, and just, my client just wants to, unless maybe mom can reach out and let them know. Or my client will try to reach out, but they won't follow anything without the order, so.
That's up to
Yes.
that's up to the defendant.
Okay.
I'm not gonna order that she contact the
That's fine.
school or anything at this point.
Thank you, Your Honor.
Ms. Martinez, anything else that you?
Yes, sir. Can you tell me how this is in the best interest of the child, being that
Ma'am,
I'm a
don't
victim of domestic violence that he pled
Ma'am,
guilty to?
file a petition if you have.
Thank you, Your Honor. Thank you so much.
Okay. Court will end this matter at 3:00 PM. You're free to go. Have a good day.
Thank you.
Thank you.
Thank you.